Good afternoon, Mr. Kahl.
Good afternoon.
We appreciate your application and we're anticipating your opening remarks.
Hey, thank you, Justice Wiggins and Commissioners. I want to start by thanking each of you for your service on the Commission and for the time and dedication you've devoted to this very important process. It is quite an honor and privilege to be considered by you as part of this process as an applicant to serve on the Iowa Supreme Court. My interest in this position is driven by a sincere and enduring commitment to public service. I aspire to this type of work not only because of long sustained experience as an appellate advocate, but also as a trial lawyer. I believe you will find that I have the skills necessary to function well as an appellate judge, the skills of writing and legal analysis and research, working with others to solve problems in a collegial atmosphere, and understanding the real and practical impact of the law upon litigants and the community. Added to that, I think you also will find a strong work ethic. To introduce myself more, I became an Iowan by choice 21 years ago when I was hired at the U.S. Attorney's Office to serve the people of the Southern District of Iowa. It has been my great honor to serve in that position ever since. As an Assistant United States Attorney, I've handled a wide variety of cases and appeared in federal courtrooms across the state of Iowa, not only here in Des Moines, but also in Davenport, Council Bluffs, and on rare occasion in Cedar Rapids and Sioux City. And the cases that I have handled in those courtrooms have arisen from both our rural communities and our urban centers. Before I speak to you in more detail about my work here in Iowa, I want to briefly touch on my background before I had the opportunity to come out here. I grew up in the Virginia suburbs of Washington, D.C., where I was fortunate to attend good public schools. My father was an electrical engineer. My mother was a school teacher. My grandparents on my father's side were immigrants who had forged a life in this country on a wheat farm in eastern Washington state. As an aside, the family lore is that my grandfather worked on a farm in Iowa as he was working his way westward across the country. I attended college in Virginia at the College of William & Mary, where I received my degree in government with honors. 3 years later, I graduated from law school at New York University. During law school, I continued to develop an interest in both courtroom advocacy and public service. For example, I served as an intern in a large metropolitan district attorney's office. I also had the opportunity to represent immigrants seeking political asylum as part of my clinical coursework. These experiences allowed me to appreciate the real-life, real-time impact of the justice system on individuals. After graduating from law school, I had the privilege of clerking for two distinguished judges. The first was Robert Coates, a judge on the Alaska Court of Appeals, which is the first-level appellate court in that state for all criminal cases. Judge Coates was a former public defender who had tremendous confidence in the justice system, believing that it would remain strong provided, so to speak, that everybody stayed in his or her lane and performed his or her obligations with skill and integrity. From working with Judge Coates, I had the opportunity to learn the day-to-day realities of criminal practice. I learned to read and understand an appellate record. I learned the qualities of economical and precise writing, which I think continue to serve me to this day. In that regard, under Judge Coates, I learned to focus my attention to the issue at hand and only to the issue at hand. In fact, if I can pause for a moment from the chronology and echo what we heard last night when Judge Kavanaugh emphasized that a judge must be independent and must interpret the law rather than make the law. In other words, to paraphrase him slightly, a judge must interpret statutes in the Constitution as written, informed by history, tradition, and precedent. This is what I learned from both Judge Coates and Judge Aldrich, about who I will speak in a moment, both of whom were laser focused on the narrow and precise issues brought before them. As indicated, I clerked next for Judge Ann Aldrich in the U.S. District Court in Cleveland, Ohio. She was a former law professor who had been a pioneer when she was the first woman appointed to the federal bench in Ohio. In her chambers, I continued to develop my legal writing skills and research abilities in broader areas of the law, examples being employment discrimination, labor management relations, intellectual property and patent law, securities law, and personal injury litigation. Perhaps more importantly, I had the opportunity to observe good courtroom advocacy skills. and to do so in the chambers of a judge who took very seriously the opportunity to engage with her law clerks and to discuss with the law clerks what had worked well and what sometimes had not worked so well in the cases before her. Like Judge Coates, Judge Aldrich emphasized continuously that the cases before her involved real people with real problems and real difficulties. I continue to learn from her as well the importance of judges entering timely rulings and decisions. After clerking for Judge Aldrich, I was hired by the Department of Justice through the prestigious honors program to serve as a trial attorney in the tax division. Although based in Washington, D.C., I spent the next 6 years of my career handling the investigation and prosecution of financial crimes across the United States. These cases were primarily in the area of criminal tax enforcement, so I had the opportunity to learn the nuances of the Internal Revenue Code in cases involving industries such as the commercial fishing industry, the gaming industry, and the motor fuel industry, among others. I also had the opportunity to prosecute other kinds of financial crimes, such as bank fraud, bankruptcy fraud, and securities law violations. Many of these cases involved lengthy grand jury investigations, and I also had the opportunity to try a number of cases throughout the western and midwestern United States. This then brings me up to 1997 when I joined the U.S. Attorney's Office here in Des Moines. I was hired initially to handle white-collar work, but over the time I've handled really all types of cases and all manner of cases that the office prosecutes, to include violent crime, financial crimes, regulatory offenses, drug trafficking conspiracy, crimes against children, among others. It has been my privilege to appear routinely before Iowa juries and Iowa grand juries, as well as before our state's distinguished federal bench. It has likewise been my privilege to work with the dedicated men and women of law enforcement whose hard work and dedication make the cases we bring possible. And I have found particularly rewarding the ability to work and interact with crime victims who are directly affected by the work my colleagues and I do on a daily basis. For many years, I served as my office's professional responsibility officer with the charge to advise my colleagues on issues of professional ethics, and in particular on issues arising from the Iowa Rules of Professional Conduct, and before then the Iowa Code of Professional Conduct, which applies to all Iowa lawyers, to include those who practice exclusively in federal court. In 2005, as Iowa was considering whether to adopt the current version of the model rules, it was my great honor and privilege to appear in this room before a special session of the Iowa Supreme Court representing my office's viewpoints and comments on the then proposed rules. From time to time, I have also been asked to take on other collateral duties for the U.S. Attorney's Office and the Department of Justice, such as by serving as an instructor at the Department's National Advocacy Center and at the Iowa Law Enforcement Academy. I've been a speaker and panelist on multiple CLE programs. I've served on working groups for the Department of Justice to address issues such as jury selection in federal court. I handled motions to reduce sentence when the United States Sentencing Commission guidelines were lowered for certain drug offenses, and I prepared recommendations for presidential commutations or reductions of sentence when those were being moved through the system. I also spent many years as the supervisor or acting supervisor of my office's criminal division, providing guidance, advice, mentoring, and direction to my colleagues. Finally, as emphasized in my materials, I have had an active and robust appellate practice during my years at the U.S. Attorney's Office. I currently serve as the office's appellate chief. That means that I have responsibility and oversight for the office's practice before the Eighth Circuit Court of Appeals, and responsibilities for developing and implementing the office's appellate strategies. I have also personally briefed and argued a significant number of cases before the Eighth Circuit, to include cases that presented constitutional and statutory issues of first impression. So to sum up, this background has provided me with the depth of knowledge and breadth of experience, I believe, that would make me an asset to the Iowa Supreme Court. My work in Iowa's federal courts will easily transfer, I believe, to the work of the Supreme Court. I deal with issues of federal constitutional law that also present themselves to the Supreme Court on a daily basis. The state and federal systems have similar rules of evidence and procedure, and other issues involving Iowa law routinely arise in my practice, such as in the context of federal sentencing, federal sex offender registration offenses, and professional ethics, just to name 3. But perhaps more to the point, I want to emphasize that I am a lifelong learner. I recognize that the law that I practice today looks very different from the law that I practiced when I first entered a courtroom. In my practice, sentencing law has changed tremendously over the last 20-some years. As another example, we have all learned to confront significant issues that arise from the prevalence of new technologies. For example, the manner in which cell phones and cell site location information is controlled by the search and seizure provisions of both the state and federal constitutions. I am sure that the practice of law will continue to evolve and face new challenges over the years. I believe I am well suited to confront those challenges as a member of the Iowa Supreme Court. I again thank you for your time, and I would welcome your questions.
Thank you, Mr. Kahl. We will start with, I got a list here. Mr. Gray.
Thank you. Mr. Kahl, you and I have met before, I think, in Cedar Rapids. But I was going to ask you, when I was listening to you, that most of the work you've been doing has been on the criminal side of the aisle. Have you had any significant experience on the civil side?
The closest I've come to having really handled cases on a routine basis on the civil side would be in the area of forfeiture, which is kind of a hybrid between criminal and civil, and has civil components to it. And I've handled some first impression cases involving forfeiture, and I've effectively used forfeiture to assist crime victims. But other than that, I would then have to really go back to my days as a law clerk to tell you when I had significant civil experience.
Well, thank you, sir.
Mr. Harbaugh? Ms. O'Brien?
Yes, thank you for your application. There are a number of studies that show a disparate impact on minorities of the criminal justice system. And I'm wondering if you see that in your role as a federal prosecutor, and then if you might comment on what, if anything, the Supreme Court should be doing about the disparate impact on minorities in the criminal justice system.
Sure. I mean, I have seen those studies, and I'm aware of these statistics. I think Chief Justice Katie pointed that out in his State of the Judiciary address in the last year or two. I think more broadly, that's not an issue that the courts are going to be able to solve on their own. In other words, that all aspects of the community are going to need to pay close attention to that information, and may need to consider, for example, what policing practices are employed, things of that nature. I think the judiciary, though, does have a good opportunity to exercise leadership in that area. There are some specific things the judiciary can be conscious of, such as implicit bias. I understand that the judicial branch has done implicit bias training across the board for all folks in the judicial branch. That's something that we need to be conscious of in talking to juries, I think. But those are some of the things that I think the courts can do in that area.
Thank you.
Mrs. Roberts? Ms. Conover? Mr. Bloom?
I don't think I have any, thank you.
Mr. Goodman? I'm sorry.
Thank you. Mr. Kahl, if you're appointed to the Iowa Supreme Court, how do you think your colleagues and parties who will appear before the court, including victims, would benefit from having a prosecutor on the Supreme Court? And I'd also like to know, are you familiar with the interpretation of 4th, 5th, and 6th Amendment issues in the state of Iowa under the Iowa Constitution as opposed to the federal Constitution? And finally, talk to us a little bit about shifting gears if you were put on the court from serving many, many years as a prosecutor, and how you would become open and avail yourself to those people who present cases on behalf of criminal defendants.
Sure. If I could answer I'll try to answer the questions in order if I can remember them. As to your first question, I believe that the skills I have developed as a prosecutor have given me the ability to understand the way the judicial system works. It will give me, it provides me with the background and deep understanding that is necessary to move on to becoming an appellate judge. In terms of dealing with criminal defendants and their representatives and their counsel, you know, that's something that I actually do on a regular basis. As a prosecutor, we engage in plea discussions, we engage in pre-indictment discussions as to whether a particular case should or should not be brought, and so somewhat as an advocate, defense lawyers meet with our office, meet with me and others, and discuss how we might handle a particular case. So I'm in a position already where there is that exercise of judgment and discretion. You had another question in the middle, which has now slipped my mind.
Are you familiar with the
Oh, yes.
interpretation of the Fourth, Fifth, and Sixth Amendments under the Iowa Constitution as opposed to that body of law that's long developed under the U.S. Constitution?
Yes, well, I'm certainly more intimately familiar with the federal constitutional law, which I use on a regular basis, but I am also aware that the Iowa Supreme Court and the Iowa Constitution have different interpretations of some of that law. I am aware of the decisions. I read the decisions. They sometimes may factor when we're making an intake decision as to whether there may be a suppression issue depending on whether the case is handled on the federal side or the state side. So I am generally familiar with that body of law.
Okay, thank you very much.
Mr. Sukup?
Thank you. During law school, you mentioned you represented immigrants for political asylum. Is history repeating itself here?
Well, we'll try to be careful in answering your question. And
Or what experience did you find from that you did apply in your federal experience now?
Well, the experience was, I mean, first of all, was an experience to stand up in front of a judge in an official proceeding. I mean, that's a very exciting opportunity for a law student, but the point I was really trying to get across is, you know, I got to understand the realities of the situation. The clinic was representing a family that had fled Afghanistan and was seeking political asylum, and they had they were lawfully in the country pending the outcome of the asylum proceedings, but they had very real concerns that were, you know, a lot more basic than the legal issues that we were thinking about.
Okay, thank you.
Ms. Stiekma?
Mr. Kahl, you moved to Iowa in 1997, began working here, but I see that you obtained your Iowa license in 2015. I understand it wasn't necessary for your job to have an Iowa license to practice law, but I'd like you what was going on in 2015 that caused you to want to obtain that Iowa license?
Oh, I mean, a couple of things. I mean, I think probably by 2015 I realized as my kids were getting far enough in school that, yeah, I really, really, really liked it here and would want to put down some further evidence of that. You know, I will tell the commission as well that I was interviewed for a federal magistrate position at that time, and my lack of membership in the Iowa Bar meant something to them, so that inspired me to you know, get off the dime and get myself admitted.
Okay, thank you.
Ms. Sinclair? Mr. Bevel?
Mr. Kahl, you made a statement in your opening statement about the judge's duty is to interpret the law rather than create the law, or something to that effect.
Right.
I owed you, we're even. Okay.
They've been stealing each other questions all day, so.
What I'd like for you to help me here, and the commission, that is said so often that I'd like to know what it means to you in this context. When I look at history, and I look at cases like Brown v. Board of Education, when that ruling came down, the Supreme Court was accused of creating law. And then I see Bush v. Gore, and people accuse the court of creating law. How do you know, what does it mean, and how do you know when you're doing it?
Well, I think in the mine run case, not those extraordinary cases that you were making reference to, it's very important, and this is what I learned from Judge Aldrich and Judge Coates, to look at the case as narrowly as possible and not be looking for the opportunity to make rulings that are not necessary, and for maybe another thought as a judge is to recognize that in some of those cases, as a judge, you're not going to necessarily like the outcome that the law demands in a particular case. Applying the law and the Constitution to the facts. I mean, obviously, the Supreme Court of the United States had to undo some damage it had done in prior cases when it made its ruling in Brown. There are certainly other monumental decisions that we can have discussions about, but in most cases, I would be paying a lot of attention to answering the narrow question and to getting an answer for the litigants.
Thank you.
Dr. Taylor?
I see the yellow lights on, so I'll try and make this brief. You've done most of your work, it seems like, at the federal court level, and now we'll be transitioning potentially to the state where, where the justices here serve all Iowans, both urban and rural. Can you talk to me a little bit about experience that you have maybe in rural Iowa and dealing with rural attorneys who don't have the resources they need, and just empathy for that and experience with that?
I think in fairness, most of the attorneys who I deal with practice in our larger centers, but to answer a related question, I've had the opportunity to deal with and work with crime victims and local law enforcement in our rural areas. I have a understanding of the different restrictions that they operate under, the challenges that they have in accessing the justice system, and so I think I do have some consciousness of those concerns.
Mr. Diaz, do you have a question, or did Mr. Bevel take care of you? Mr. Berger? Ms. Bowden? Ms. Pearson? I don't think I have any questions either, so I would like to thank you on behalf of the Commission for coming here today in your application and wish you the best of luck.
Thank you very much, Justice Wiggins.